Getting a divorce in Iowa is actually simpler than you might think. If the receiving spouse is an Iowa resident and personally served the divorce papers, there is no residency requirement for the spouse filing. Otherwise, the requirement is 1 year. In addition, a 90-day waiting period is in place before a divorce becomes final. The divorce may be filed in the resident county of either spouse. Once the residency requirement is completed, a legal grounds for a divorce must be established. Both general and no-fault divorce are acceptable grounds for divorce. The no-fault reason is breakdown of the marriage relationship to the extent that the legitimate objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved. The general reason is the only grounds for dissolution of marriage in Iowa are that there have been a breakdown of the marriage relationship to the extent that the legitimate objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved. Iowa requires a parenting plan for child custody. Joint or sole custody may be awarded in the best interest of the child and in such a manner that will encourage the parents to share the rights and responsibilities of the child. Joint custody may be awarded if requested and in the best interest of the child, and based on the ability of the parents to cooperate, the ability to support the child's relationship with the other parent, the physical proximity of the parents to each other, the fitness and suitability of the parents, the reasonable preference of the child if the court deems the child to be of sufficient intelligence, understanding, and experience to express a preference, whether both parents have actively cared for the child before and since the separation, whether the psychological and emotional needs and development of the child will suffer because of lack of contact with both parents, whether the safety of the child would be jeopardized by an award of joint custody or unsupervised visitation, whether one or both parents agree to or are opposed to joint custody, and any history of domestic abuse. However, joint custody may be granted even when both parents do not agree to it. Either or both parents may be ordered to pay child support. Payments may be made directly to the court. The court shall order a parent to provide a health benefit plan if available at a reasonable cost. Iowa is an equitable distribution state. The court divides all property except gifts and inheritances. A portion of the property may be set aside for the support, maintenance, and education of any children. The following are considered in any division: the contribution of each spouse to the acquisition of the marital property, including the contribution of each spouse as homemaker or in child care, the value of any property brought to the marriage, the contribution by one party to the education, training, or increased earning capacity of the other, the length of the marriage, the age and physical and emotional health of the spouses, the vocational skills of the spouses, the time and expense necessary to acquire skills and training to become self-sufficient, the federal income tax consequences of the court's division of the property, any premarital or marital settlement agreement, the present and potential earning capability of each spouse, including educational background, training, employment skills, work experience, and length of absence from the job market, whether the property award is instead of or in addition to alimony and the amount and duration of any such alimony award, the total economic circumstances of the spouses, including any pension benefits, the desirability of awarding the family home to the spouse with custody of any children, any custodial provisions for the children, the amount and duration of any maintenance payments, and any other relevant factors. Maintenance may be granted to either spouse for a limited or indefinite time, based on the time necessary to acquire sufficient education and training to enable the spouse to find appropriate employment and become self-supporting, the duration of the marriage, the financial resources of the spouse seeking alimony, including marital property apportioned to such spouse, and such spouse's ability to meet his or her needs independently, the tax consequences to each spouse, the age of the spouses, the physical and emotional conditions of the spouses, the work experience and length of absence from the job market of the spouse seeking alimony, the vocational skills and employability of the spouse seeking support and alimony, the probable duration of the need of the spouse seeking support and alimony, custodial and child support responsibilities, the educational level of each spouse at the time of the marriage and at the time the action for support is commenced, any premarital or other agreements, the earning capacity of the spouse seeking maintenance, including the educational background, employment skills, and work experience, feasibility of spouse becoming self-supporting at the same level of the marriage, and any other factor the court deems just and equitable. Marital misconduct is not a factor. Maintenance payments may be made through the court. Upon request or by the court, the spouses may be ordered to participate in conciliation for 60 days. A course on children's needs is required when custody is debated within 45 days of the beginning of the case. Visit us today at www.mydivorcepapers.com and click on Iowa at the bottom of the page. Let mydivorcepapers.com help you file for divorce today.